Hey there, everybody. Estate planning attorney Paul Rabelais. Here's the topic of today's video: when your adult child can't handle a lump sum inheritance. All right. So here's the deal. You want to leave an inheritance to your children. Let me make sure we've got some things going right here on all of our settings. And give me a second. And okay, we're good. All right. So you're ready to put your estate in order. You want to leave your children inheritance, but what if you know that one of your children, or maybe more than one of your children, just kind of aren't ready to receive or to handle a lump sum of an inheritance? Maybe they have spending issues. I've heard it all. Sometimes people will tell me, Paul, my son, he doesn't, he's 29 years old. He doesn't contribute to his 401k. I try to drill into his head that he needs to contribute to his 401k because his company will match some of it. He won't do it. I try to preach to him about how he ought to be, putting away money each month, and it can compound and it will grow. And over 30 or 40 years, he'll amass a fortune if he just starts putting money aside, but he won't put a penny aside. In fact, he's got a bunch of debt. He's bought cars, he's bought boats, he's got some other debt, he's got a bunch of credit card debt. He can't save enough money to buy a house. So, I hear that from a lot of people: spending issues. And then I hear addiction issues, terrible, alcohol, drugs, whatever. It's a nightmare. So sometimes families have to face that as part of their estate planning. Sometimes there's just poor money management, poor money management skills of the children. Sometimes children are vulnerable to bad influence. If I've heard it once, I've heard it 1,000 times. Paul, but my daughter, we raised her well. She started a savings account when she was 15 years old. She had a summer job. She'd saved money, but then she met someone, and that someone just influences her into spending everything they have. It's a real mess. So there's a lot of reasons why people feel like their adult children, really, it's not in their best interest to receive a large lump sum inheritance. So what do you do? Well, in this video, I'm going to explain how you can structure your estate plan to protect your child and protect your legacy. So this is a common concern. And it's common because I've dealt with thousands and thousands of people over the years, thousands of clients, many of them married couples. Most of them, of course, there's exceptions to just about every rule I'm going to tell you, but most of the people, by the time they get to me, by the time they get to an estate planning attorney, it's likely they're in their 50s and 60s. So if they're 50s and 60s, and if they kind of follow the normal path of life, then they have kids who are probably in their 20s. And so I hear a lot, from the husbands, for example, will say, all I know is when I was 25, I sure wasn't ready to inherit $1 million. Or when I was 25, if somebody would have left me $3 million, I would have quit my job. I would have done this. I would have done that. I would have spent it. So I hear a lot of that. And so a lot of parents are saying, since I know I couldn't have handled it when I was 25, I don't think my kids can handle it either. So there's a lot of different planning options here when trying to determine what's in the best interest of your child or your children. And most of it revolves around leaving assets to a trust. But let me tell you this kind of from the get-go. I talked about how the dads will say sometimes, when I was 25, I couldn't handle that kind of money. So let me, and again, there's exceptions to every rule, but let me address some of the issues. Sometimes it's the moms that have this issue. And so let's say you've got a married couple, they have 3 children, maybe 2 of the children are very responsible, and one child just isn't, for whatever reason. They just can't handle money. A lump sum inheritance would be the last thing that one child could benefit from. And so a lot of parents in their 50s and 60s, they have trouble treating, one child. Well, we're going to treat this child where we're going to restrict them from being able to control all of their inheritance because they're not ready to handle a lump sum. But the other 2, we're just going to let them have theirs because they've shown that they're responsible. Let them have it. That doesn't float well with a lot of parents because they don't like the idea of treating different children differently. So you got to get past that. And so, but when you can't get past it, some parents have parents will tell themselves they're either like, boy, we're going to restrict all of them from receiving their inheritance, oh, and under the terms that we address. Or parents will say, I know we've got this one child that can't handle money and two that handle it really well. We really don't want to treat one different than the others. So let's just let all three of them have it in a lump sum. And then they usually come back with, we'll be dead. So it doesn't really matter, as their way to kind of justify leaving it to all of them in a lump sum. All right. So be aware that there is a major issue. And if you're a couple trying to figure this out, maybe you want to talk about it amongst yourselves. Do we really want to treat one child different from the others? Or if we feel so strongly that it's not appropriate to leave this one child a lump sum of $1 million, $3 million, $500,000, or whatever it might be, then are we okay kind of treating that child different than the other, quote, responsible children? Or do we want to treat them all the same, whether you restrict all of them or whether you restrict none of them? Okay. So since the answer is leaving things in a trust, so as us lawyers call it, you're either going to leave the inheritance to your children. And look, by the way, when I say children, it could be grandchildren, it could be nieces, nephews, it could be people who are unrelated to you. Most people, again, exceptions to every rule, most couples, have children, and so they want to leave the bulk of their estate to their children. And so this is, 60-year-old couple with kids in their 20s, 55-year-old couple with kids in their 20s. They're like, we don't know if our kids would be ready to handle a lump sum inheritance, so we need to hear some of these options. So the option is, again, you can leave it to them outright or leave it to them in trust. And really, most of what we're talking about here is leaving it to them in trust. If you're comfortable leaving it to them outright, and you have a lot of, that gives you a great comfort level, by all means, leave it to them outright. In fact, many, many people do that. So there's nothing wrong with leaving an inheritance outright to children when you know that that's what's best for them. So, but many parents say, I don't know about that. So now we got to explore what are the options when it comes to leaving it in trust for them. So let me give you an example. Let's say a married couple does have three children, and they and maybe two of their children are very responsible. They're in their early 30s, late 20s. Maybe they have a younger child. Doesn't really matter the age of the child, and doesn't really matter whether they're the oldest, middle, or youngest child. But that one child, just for whatever reason, has spending issues. Never has. You just know that if you dump $3 million in their lap, it's going to be gone. Within a couple of years. Trips, boats, gambling, addiction, maybe, spouse who has influence, divorce, who knows? So what do you do to protect that inheritance for that child? We're just going to focus on that one child for now. All right. So what you're going to do, likely, probably where you're going to wind up with after, there's some decisions that we're going to talk about here, but you're likely going to say, okay, after we both pass away, mom and dad, then the inheritance for, let's call him Jethro. The inheritance for Jethro is going to be left in a trust. Now you've got some decisions to make. All right. So one decision is, who's going to be the trustee of that trust? Some parents will ask me, do we really have to have a trustee, or can we just kind of say he'll get X amount per year, or he'll get, and like, no, you have to have a trustee. So since you have to have a trustee, every trust has a trustee, then we're going to have a conversation about who should be that trustee. So that trustee is likely going to be an individual or individuals, or it could be a corporate trust company. I'll call it that. And so who might be, so you're saying, and you're hearing, we really don't want to leave Jethro $3 million. Again, could be $300,000, could be $1 million, could be $10 million. But in this set of this example that we're using, this case study, we're just going to say that Jethro's portion of the estate is $3 million. I know it's a big number, but more fun that way. So you've kind of made a decision. It wouldn't be best for Jethro if, when we pass away, it just $3 million gets dumped in his lap. So let's hear about what these options are, and let's hear about what this trust thing is, and we'll decide what we want to do from there. So again, first decision is, first of several decisions is who's going to be the trustee of that trust. And so then, you've got individual trustees, you've got corporate trustees. Let's talk about individuals for a minute. So maybe Jethro is the youngest of three children. And so maybe what pops in your mind, yeah, maybe his older sister or his older brother could be the trustee of the Jethro Trust. Maybe you think that's a good idea, and maybe you think it's a bad idea. The people who think it's a bad idea typically say something like, "Well, we don't want Jethro kind of badgering his sibling to make distributions to Jethro after we're both gone. We don't want to do anything to harm the relationship of Jethro and his sibling." So naming a sibling of I'll call it irresponsible child, it may or may not. It all depends on your family dynamics, but just be aware there could be some conflict issues that might arise after you both pass away when that irresponsible Jethro kind of badgers their sibling, and the sibling got their inheritance outright. And so really kind of tricky there. So maybe you're thinking, well, maybe I'll name my brother. My brother knows Jethro very well, and my brother can be the trustee for Jethro. And my brother can say no, no problem. My brother can say no if Jethro tries to, badger my brother after we pass away for distributions of Jethro's trust to Jethro. Problem with naming your brother is, and you're 60 years old, and let's say your brother is 62 or 58, you and your spouse may live another 30 years. So we don't know if your brother is going to be around and available to be that trustee to handle the trust for Jethro after you and your spouse pass away. Maybe you have a family friend, but anyway, a lot of people, once they kind of tell me, I think I know who I'd want this person to be the trustee for Jethro. Well, you got to realize whoever you're thinking of as this person to be the trustee of a trust to handle your child Jethro's $3 million inheritance after you pass away. I'd guess that this individual that you're thinking would be the best trustee probably has never been a trustee of a trust like this before. So it's their first time doing it, and there's lots of investing that has to take place, lots of accounting that has to take place, lots of legal stuff involved. So just by kind of naming an individual because you think they know Jethro pretty well, and you think they know what's going to be in Jethro's best interest, be careful about appointing just some relative or friend as a trustee of a trust that may go on for many years. You may not be doing that friend relative any favors. So there are issues with naming individuals as the trustee of a trust for your child to manage all of those assets, take care of all of the accountings that they have to take care of, not only with the IRS, but they have to provide accountings to Jethro and all the legal stuff that they have to deal with. So that's an option is if you have a child, you don't want to leave them a lump sum, leave them their inheritance in a trust. One option is naming an individual or individuals as a trustee or co-trustees. Another option is a corporate trustee. All the big financial institutions have their own trust company. It's a separate entity. Vanguard, Fidelity, Schwab, they all have their trust companies. And so some people say, yeah, I think it would be better if we have a corporate trustee handle the inheritance for Jethro after we both pass away. So there's some concerns about that. If you're going to leave Jethro $200,000 of an inheritance, but you want to leave it with a corporate trustee involved, probably not going to work because the corporate trustees, they like managing the larger account balances. They earn their revenue based on the assets under management. They want to manage more assets. Every corporate trustee has a different threshold under which they won't even accept the position of trustee unless that those trust assets exceed a certain amount. That amount might be 1 million, it might be 3 million, it might be more. So that's a concern when you're trying to select a trustee who's going to handle the money for your child or children after you and your spouse pass away. So another thing, well, maybe a couple of other things that people express concerns when we talk about a corporate trustee is that corporate trustee often doesn't have a relationship with your child, rarely would have a relationship with your child. And so they may not know uh, the the need and understand the needs of your child after you pass away in order to exercise discretion that you may give a trustee to make distributions to or for your child. It's kind of a cold relationship where trust companies have trust officers, and their job is to kind of get to know that beneficiary and understand what that beneficiary's needs are. But they're probably not going to know your child's needs as well as maybe a close relative or a close friend might understand those needs. That's why if you do have a corporate trustee, really important that you during your lifetime establish a relationship with that corporate trustee. Leave perhaps a letter of instructions as to how you'd like the corporate trustee to exercise the discretion that they have, perhaps in making distributions to your child after you pass away. So there's that. Do we have a corporate or individual trustee decision? Another concern, which I think people kind of make this an over concern, more of a concern than it needs to be, is that corporate trustees charge fees. Yes, they charge fees. So and as well, they have to earn a profit, they have to earn revenue, and it's always based. I say almost. Typically, it's based on the assets that they are managing. You and your spouse pass away, $3 million goes into the Jethro Trust, and the corporate trustee is the trustee. So their fees are based on the assets under management. Might be 1%, might be 1.5%. It all depends on what their fee schedule is, and their fee schedule probably staggers based on the size of the account that they are handling as a corporate trustee. So, but you know. They're going to invest the money. They're going to dot their I's. They're going to cross their T's. It's going to be professionally managed. So really, people shouldn't just immediately exclude a corporate trustee for the sole reason that corporate trustees are going to charge fees. In fact, if you have an individual trustee, as much burden as you're putting on that individual trustee, you probably wouldn't want them to do it for free, and they probably wouldn't want to do it for free either. So, even if you do name an individual trustee, it's a mighty task that you're going to be giving them probably for a number of years, and probably want to provide for compensation to that individual trustee as well. All right. So, now that we've gone through you're kind of like, yeah, we think Jethro, he just can't handle money. He doesn't have a pot to in. And so we don't envision Jethro ever having any savings based on the way he behaves right now. So we do feel like we need to leave Jethro's inheritance in a trust. Looks like it might be around $3 million or more, depending upon how long we live and how well our investments do and whether our estate appreciates in value. So it could be $6 million, could be more. So yeah, let's look at this trustee. And so let's say the parents decide on a trustee selection. It might be an individual, it might be a corporate, might be something combined that I'll talk about in a little while. But now let's move on to the kind of distribution discussion that has to take place when parents decide to leave their assets to an adult child in a trust. So one of the decisions is what happens to the trust income. So let's say you and your spouse pass away, you leave $3 million to the Jethro Trust. That's going to be invested. That's going to produce some income. Could be interest income. Could be dividend income if the account holds stock. Could be rental income if the trust has some rental property. And I'm not really talking about capital appreciation. Yes, investments are going to appreciate in value. I'm really talking about income here, and there's a difference between the two. So we're talking about things like interest, dividends, and rental income. What happens to the income every year? $3 million. It's going to produce some income. How much income is it going to produce? Who knows? Let's say it produces $100,000 of income in a year. What happens to that income? Well, many parents say after getting informed of the options, many parents will say, let's let Jethro go ahead and get the income that his trust produces every year. And maybe if they were really informed, they decided that for maybe some income tax reasons. Because if that income gets distributed to Jethro, then yes, he gets that income. He pays income tax on that income. and the trust doesn't have to pay any income tax on that income. See, that what happens here is an individual's income tax rates are lower than trust income tax rates. I will tell you, it's the same. It's the same rate structure, but Jethro, as an individual, he may not get to the top, let's call it 40% income tax rate, unless he has, I don't even know what the number is, but let's call it $400,000 of income. Where a trust gets to the top income tax rate, call it 40%. When a trust has, I don't know the exact number, but let's call it $15,000 of income. So if that trust income can get distributed to Jethro, it's likely that less income tax will be paid on that income because Jethro will pay it at an individual's income tax rates, rather than if the trust accumulates that income and doesn't distribute it to Jethro. If the trust accumulates that income, then the trust pays income tax at higher trust income tax rate. So a lot of parents, after kind of learning all of this, say, yeah, let's go ahead and make sure that that trust income, $3 million trust, $100,000 of income annually, that's about, I think that's about maybe 3%, income. Let's go ahead and make sure that gets distributed to Jethro. So he can have that, and he'll do whatever he wants to with it, and he'll have to pay the income tax on it. And so let's go ahead and make sure the income gets distributed to Jethro every year. So that's the trust income decision. And maybe the bigger decision is, well, when does the trust principal get distributed to Jethro? What is the trust principal? Well, the trust principal is the $3 million of assets that produced that $100,000 of income in a year. So when does Jethro get the trust principal? And there is an unlimited number of ways to stagger that. By the way, I'm going to go through all of the different ways. Like, for example, you could say that he gets it when he's 50. Not a real common scenario because there's a lot of different ways you can do this. But let's just say, so I can explain a couple of things, that you decided that Jethro gets all the principal when he's 50. Under all of these ways to provide how Jethro gets principal distributions from his trust, you also can determine whether you want the trustee to have the discretion to distribute principal prior to these termination dates, if the trustee, in their discretion, feels like it's in the best interest of Jethro to receive a principal distribution. We often say that the trustee can make principal distributions at any time to Jethro for Jethro's health, education, maintenance, and support. A lot of people call it the HEMS standard, HEMS, health, education, maintenance, and support. So if you do say that Jethro gets all the income, $3 million trust, $100,000 of income, he gets that, annually, gets that income annually, or at least annually, and you say he doesn't get the principal until he's 50, you'll also make a decision of whether you want to give that trustee the discretion to make additional distributions to Jethro before he's 50 for his health, education, maintenance, and support. So that's another, do you want to allow the trustee to have that discretion to make additional principal distributions if, in the trustee's discretion, it's in the best interest of Jethro to do. So I'd say most parents, especially if they really trust that trustee, they're going to give that trustee the discretion to be able to make distributions to Jethro, because who knows what Jethro's needs might be in the future, and it may be really important that that trustee be able to make distributions to Jethro even before this trust terminates, and Jethro automatically gets his hands on everything. Okay, so that's one way to provide for when Jethro gets his hands on the principal, and it's at an age. So right now, the parents are 60 trying to build their estate plan. Jethro is 25 and irresponsible. So maybe the parents say, if after we pass away, let Jethro get the income every year, and then when he's 50, he can have the principal. That's one way to do it. Another way to do it is stagger those distributions, and there's a couple of different ways to stagger those distributions. Some people say, Well, when Jethro is, and I'm making these numbers up, when he's 35, he can have 1/3 of the principal. And when he's 45, he can have another 1/3, or as we say it in the documents, 1/2 of the remainder of the principal. And when he's 55, he can have what's left of the principal. So a lot of parents kind of like that. They're thinking in their mind, yep, they can get that first distribution at that certain period. And boy, if they blow it and they mess it up, let's hope they learn from it so that when they get their second big distribution 10 years later, they'll be more responsible with it. And by golly, if they really mess that one up too, then maybe they'll really learn from it before they get the third distribution. So that's another way people do it, stagger it according to ages. Another staggering option is, especially if your children are, they're adults. Again, the couple who's creating their estate plan is 60 years old, and they're thinking they're probably going to live another 20 or 30 years. So this whole staggering it for Jethro, who's 25, at 30, 35, and 40 doesn't do any good, because you're probably going to live another 20 or 30 years. So some parents will say, well, whenever me and my spouse pass away, that's when Jethro can have that first distribution of 1/3 of the principal. And then 5 years later, 7 years later, whatever you decide, that's when Jethro gets that second distribution of 1/2 of what's left. And then the third distribution, another 5 years later, 7 years later. So that's a way, because you don't know how long you're going to live. Let's just say he gets, a third of it after you and your spouse pass away. Now, when we do that, Jethro's 25 right now. Maybe you also say, look, once Jethro's 50, if we pass away then, or if there's anything left and he's 50 in his trust, because we have passed away, just this whole thing, trust will end, and he can just have it at 50. So if you and your spouse pass away and Jethro is 51, he just gets it. Maybe you put something like that on there. All right, another way to do it is, we've seen some parents like the idea of, they'll tell me, Paul, we kind of know what our son's bills are, and we feel like we'd want him to get a certain amount every month. And so some parents will say, Paul, let's set up Jethro's trust. So, his 1/3 of the estate, we have 3 children, Jethro's 1/3 goes to the Jethro Trust, and so will be the trustee. And let's provide that the trustee is to give Jethro $4,000 every month. Because in their mind, they're thinking, yeah, to pay Jethro's rent or mortgage or car note or insurance or food expenses or whatever. They're thinking, yeah, what that $3,500 will cover Jethro's basic needs. Well, let's give him $4,000 a month. And then there's a couple of other decisions. Do you make it $4,000 permanently? Do you have that $4,000 a month adjusted for inflation every year, so it goes up a little bit? A lot of parents like that. So it's kind of $4,000 a month, probably adjusted for inflation, until it just runs out. So, we used a big number in our example. In our example, we used Jethro's portion of the inheritance was $3 million, $4,000 a month. That's $50,000 a year. Maybe that $4,000 a month will never run out. And so maybe, so all those decisions that you have to make on how much he gets every month, if you want to do a fixed dollar per month distribution schedule on the trust that you leave to Jethro, you got to factor in kind of the total value. How long will that last? And so those are all factors that come into the, let's leave him an X amount per month. All right. Then another way to do it is you say, maybe you say, you know what, I'm going to name Jethro's uncle, my brother, as the trustee to handle this after me and my spouse pass away. I trust my brother implicitly. My brother is going to do what's best for Jethro. We don't know how Jethro is going to turn out over the next 10, 15, 20, 30 years. So let's do this. Let's leave Jethro's part in a trust for him. And let's not say that he gets his hands on it, Jethro gets his hands on it automatically at any specific age. Let's give my brother, the trustee, the total discretion to determine whether Jethro gets income, gets principal, because we just don't know how Jethro is going to turn out, but we know our brother's going to do what's best for Jethro. So some people say, I want to give that trustee total discretion to determine, when Jethro would get distributions. There's a couple of others that, I don't really like what I'm going to call the incentive trust, because we have no idea what the future holds. For example, I've had a lot of requests and created some incentive trusts. One example is, all right, I'll tell you what, if let's set up the Jethro Trust so that after me and my spouse pass away, Jethro's part of the estate goes to the Jethro Trust, and I want to create some incentives in there for Jethro, is what the parents say. And so the parents say, I want to make sure Jethro has a job. And so if he has a job and he has some W-2 income, then the trust will match what Jethro received as a W-2 employee for his full-time job. He has to be working full-time. So great thought, hey, double the salary, great. But we don't know what the future holds. There might be a circumstance where, I'll just pull stuff out of thin air. Maybe Jethro gets sick and he can't have a full-time job. Maybe Jethro is not the wage earner in his family. Maybe he has a spouse, and his spouse is the wage earner. So Jethro would never get distributions because he didn't have a full-time job. So got to be real careful on these incentive provisions, because you really you don't know what the future may hold. All right, a couple of other issues. Those are some of the kind of trust distribution provisions, and then just a few other miscellaneous provisions. Just as you go through this, you need to understand what some of these provisions mean. Just about every trust that we set up for children, parents set up for children, we make it what's called a Spendthrift Trust. Especially in a circumstance like this, where you have a separate individual or corporate trustee who handles things for the benefit of your child who's not good at handling money. You want to make sure all those spendthrift provisions are in your trust, and they typically always are. But that does a couple of things. Your child, Jethro, he can't use his trust as collateral for a loan if those spendthrift provisions are properly written into the trust. And also, spendthrift trust means that if Jethro gets a judgment against him, he gets sued, and somebody successfully sues him for $10 million, nobody can take his trust from him, because of these spendthrift trust provisions prohibit that. All right, couple of other scenarios. I mentioned this earlier briefly, so I'll tell you about it later. Sometimes people like the idea of naming a corporate trustee to handle all of the investments and the management of the trust assets, particularly if the investments are going to be stocks and bonds and things that financial institutions typically handle. But then they'll name an individual as what I'm going to call the distribution trustee. So you've got a corporate trust company handling all the investments, and then you've got an individual, maybe somebody who knows your irresponsible son Jethro and knows what his needs are, who can better determine whether distributions should be made to or for just Jethro. So you have that corporate trustee who handles the investments. That distribution trustee perhaps is an individual who has the ability to go to that corporate trustee and say, I want to make sure that this expense is taken care of for Jethro. Might be education, might be a down payment on a house. Or that distribution trustee could say, I want you to make a $5,000 distribution to Jethro, because Jethro is proving that he can handle it. And so with that authority that I have as the distribution trustee, I'm going to direct the corporate trustee to go ahead and make that distribution to Jethro. So that's a combination of a corporate trustee and an individual distribution trustee. Now, how do you do all of this? Really two different ways to do it. If you're kind of new to this, you're probably thinking this couple who's getting their estate plan in place has wills. And so, but wills are kind of the traditional and old-fashioned way to do this, but it's one way where parents in their wills say, and I'm going to keep it real simple, they say, when I pass away, I leave 1/3 of my estate, because I have 3 children, but Jethro's the one who's irresponsible, and he's 25 years old. I leave 1/3 of my estate to the Jethro Testamentary Trust. So a testamentary trust is a trust, the terms of which are in someone's last will and testament. So dad has a will, and let's keep mom out of it for now to keep things simple. Dad has a will, and dad's will leave my estate three ways equally. However, Jethro's to my three children, but Jethro's portion will go into the Jethro Testamentary Trust with so and so as the trustee, and then all those distribution terms and all the other terms are laid out in dad's will. So you've got a will and then a testamentary trust within the four corners of that will. Some people think when you have that, then when dad dies, then some lawyer has to prepare the Jethro trust, but that's not the case. All the terms of that trust are part of dad's will, called a testamentary trust because it's in dad's last will and testament. That's one way to do it. The downside of doing it that way is when dad dies, all those assets that are in his name, they've got to go through a court and attorney involved probate proceeding to get from dad's name to the Jethro Testamentary Trust. So it requires that probate, which is expensive and takes a long time. And so there may be a pretty long gap before Jethro starts getting some of those distributions that he'd be entitled to under your will, because probate takes time. But that's the case, and it's done that way, often. The other way to do it, probably much more common and probably much more efficient, is where mom and dad, John and Jane, I'll call them, John and Jane, set up the John and Jane Living Trust. And they transfer assets that are in their name, their real estate, their brokerage accounts. They transfer those assets from John and Jane to John and Jane as trustee of the John and Jane Living Trust. The John and Jane Living Trust says what happens after John and Jane die. And then, of course, the John and Jane Trust says after we both pass away, Jethro's part will go into the Jethro Trust. Technically, I'm going to call that the Jethro Trust a subtrust within John and Jane's Living Trust. So if John and Jane did it through their wills, they would have their wills, and then they'd have the Jethro Testamentary Trust. But John and Jane want to avoid their survivors having to go through that lawyer and court involved process when they pass away. So John and Jane set up their living trust. They transfer assets to their living trust during their lifetime. That way, after John and Jane pass away, that successor trustee or the trustee of Jethro's subtrust really can step in right away and start managing assets for Jethro, making distributions in accordance with the trust instrument. So again, two ways to do all of this: through your will. And when you do it through your will, things will go through probate when you pass away. Once that probate is complete, then assets will land in that testamentary trust for Jethro. Or you can, if you want to avoid all the court and attorney involved process, you'll set up your living trust, and then all of the terms of Jethro's trust will be in that subtrust, which again likely could be all within the confines of your living trust instrument. So it is common for a living trust to have sometimes several subtrusts. The terms of those subtrusts are all within that living trust. Okay, and I will also say there's probably special consideration if you're like most people and most of your money is in your traditional IRA as opposed to Roth IRA, because a traditional IRA has greater income tax consequences. So when someone inherits an IRA like Jethro after mom and dad pass away, there are required distribution rules that say that distributions must come out of that IRA within 10 years after mom and dad both pass away. So if it all works out, maybe, just maybe, it depends on how much confidence you have in Jethro, maybe you name Jethro as just a beneficiary of your IRA in his own name, just like you do with your other two children. And then all of the other assets get left to a trust for Jethro that he'll get, over time. So you don't have to do it that way. It's just when you name a trust as a beneficiary of a traditional IRA, it just confuses everybody. It usually confuses the lawyers, the financial institutions, the CPAs. It confuses Jethro. So if you can swing it, it's always easier if you name individuals as beneficiaries of your traditional IRA. But if you're like, no way, Jethro's portion of my IRA would be $1 million. Last thing I want to do is leave him $1 million. Now I realize he'll have to pay income tax on it when he gets it. But there are ways that you can leave an IRA to a trust. An IRA can't be an owner, but it can be. A trust can't be an owner of an IRA, but it can be a beneficiary of an IRA. We just have to take into account all of the required distribution rules when leaving an IRA to a trust. So all doable, but just kind of be aware that that's an issue. All right, so let me jump over to a couple of these things here. One of my siblings stole our mother's entire estate. Why do the ones who? That's a good question. So let's see here. Got that one. So Melanie, you've got some issues. Mark, thank you. It's very helpful along with other videos. If your firm was located in Dallas, I would be interested in hiring you. Well, Mark, I will tell you, we help a lot of Texas people. So my law partner is licensed in Texas. In fact, we help people all over the country. And it all starts with a Zoom meeting, and that you can click on a link in the description and request that Zoom meeting with me. And I've had this YouTube channel for about 8 or 9 years, and we get requests from people all over the country. So we have set up our business, and we do get other lawyers in other states to participate, but it all starts with me. So, but certainly I'm in Louisiana, and we help a lot of people in Texas as well. In fact, we help a lot of people in other states as well. So for what that's worth. Yep, same thing, Melanie. Although Melanie, I can't help you with that problem you're going through. We don't handle any of the kind of litigation stuff. How to prove incompetence says trustee dad has remarried, then filed divorce, stealing cash, then cancer. You got a mess on your hands. I'll just leave it at that. All right. How would you recommend? Good question, Melanie. Recommend approaching elderly parents to suggest all of these options. Maybe it's as easy as, Mom and Dad, I'd like you to watch this video. And then just, if these are the options that you want to present to Mom and Dad, maybe you just let me present those options in a video to just as a conversation starter. All right. Hey, Susie and Aspen. So very good. All right. So very good. Very excited about what we've got going on. I've had some audio problems the last couple of times I've done this, but this worked, and we will see you next time. Take care.